The following podcast contains opinion and commentary protected by the First Amendment and fair use. It may also contain adult themes, adult concepts, and adult language not suitable for children. Viewer discretion is advised.
Oh, honey, there's guilty. And then there's Laura and Gingras guilty. Better grab your hymn book and a subpoena. Oh, strutted in like courtroom gold. That's Gingras. Spinning tales that'll make a preacher fold. That's Gingras. He said, I'm noble. We said you yes. That's Gingras. Then he hitched his name to a federal mass. I stand for truth with a briefcase of lies. I'm just doing my job while justice cries. Don't question my ethics, too late for that vow. I believe in Laura, well look at her now. The devil's got a law degree, oh yes he do. Writing checks with his mouth in a three-piece suit. Took the stand with a wink and a vow. Now he's headline news with a furrowed brow. It's Gingras, baby, just wait and see. When you cozy with crooks, you catch legal debris. And when the cuffs come out and the cameras go out, look at me, daddy, I'm a real criminal now. Laura said I'm innocent, pinky swear, but the charges stacked like courthouse stairs. Indictments rain and alibis run dry, but Gingras just smiles like a courtroom spy. His license got clipped, just a slap on the wrist. 30 days off for a perjury twist. But baby, the bar's got long memory, and the devil keeps every receipt he sees. They play pretend with the holy roll, but forgot the judge sits high above the globe. You can't twist the law but not the truth, and the jury don't dance to a con man's tune. The devil's got a law degree, that's a fact, and his star client's got the feds on her back. You can coach the crime, try to scrub it clean, but your fingerprints still light up the screen. It's Gingras, baby, and Miss Owens too. When you lie in court, hell rehearses for you. Now the verdict's close, and the angels shout, look at me, daddy, I'm a real criminal now. Ooh, criminal. Law, Haman, indictment, and the due.
Welcome, everyone, back to your favorite cubbyhole on the internet over this Labor Day weekend. We have returned for yet more Laura Owens. Last episode, we covered the requested declaration for the filing of indigency for Laura Michelle Owens, indicted felon. And today and in subsequent editions, we will cover the latest DVRO filings, beginning with our first one. But before we get to that, just a little plug on future work. We are preparing a special report about this case. Well, actually, sort of about the previous case as well. We have an elusive figure we are trying to get to the bottom of a little bit further than happened on the first go-around. So we are preparing a special report on the elusive figure created by Laura Michelle Owens, Chase J. Jones. We have some legitimate boots on the ground investigative journalism happening, and we're excited to bring that to you once that episode is ready. So stick around for that in the future. I hope it'll be good. We'll see. We've got, press inquiries out to the business, and there will be some on-site video. So we'll just see what happens. All right, now today's topic. Today's topic is the motion to disqualify Dingus the Douche Canoe.
The fucking douche canoe.
The motion to disqualify petitioner's counsel. It is, of course, prepared by the amazing and very capable, if not talented, Omar Serrato. And it reads, there's much to read here, so we're going to try and get through this quickly. I will make a little confession. I've already done this once, And for reasons beyond me, OBS decided it wanted to change audio settings without my permission. So we're going to do this a second time. I will admit the witty repartee that happened the first time is probably not going to happen the second. So this might be a little bit less entertaining than the first attempt, but it is what it is. So we shall carry on. We will do so with perhaps some minor adjustments, and we'll see how those go when we get there. The filing reads, to petitioner Laura Owens and her attorney of record. Please take notice that on October 10, 2025, 8:30 a.m. in Department 405A of the San Francisco County Superior Court Family Division, Respondent Mike Marraccini will and hereby does move for an order disqualifying David Gingras, Esquire, from representing petitioner Laura Owens in the pending Domestic Violence Restraining Order renewal proceeding in this action. This motion is made on the following grounds, each an independent basis for disqualification. Conflict of interest. Mr. Gingras has a personal conflict of interest that materially limits his ability to represent petitioner. He is the subject of a pending state bar disciplinary proceeding arising out of his conduct toward respondent in this case. A state bar court order of probable cause has been recommended. Gingras has stated he intends to use this case to elicit testimony from Marraccini that will aid in his defense in the investigation into his misconduct against Marraccini. Mr. Gingras' personal interest in defending his own conduct and license creates a concurrent conflict of interest between his interests and those of his client in violation of Rule 1.7 of the CRPC. Mr. Gingras is a necessary witness on pivotal, contested factual issues in the DVRO renewal hearing, specifically his alleged misuse of law enforcement to have respondent arrested on a baseless charge of violating the DVRO, which is also the subject of the bar complaint involving Marraccini, for which the Arizona State Bar has recommended an order of probable cause. Mr. Gingras' dual role as an advocate and witness contravenes Rule 3.7, the advocate-witness rule, which generally prohibits an attorney from acting as trial counsel in a matter where he is likely to testify on material matter. None of the narrow exceptions to this rule apply here, as Mr. Gingras' testimony relates to a hotly contested incident central to the case, not to an uncontested issue or mere formalities. Petitioner's consent, if any, to Mr. Gingras' dual role does not resolve the problem. Courts retain discretion to disqualify an attorney witness, notwithstanding client consent, to prevent prejudice to the opposing party or confusion of the fact finder. In the footnotes, we have the following. In Doe v. Yim, courts may remove counsel even with informed written consent to prevent prejudice and to protect the judicial process. The advocate-witness rule exists to avoid jury confusion and conflicts between advocacy and testimony. Footnote 2, in Geringer v. Blue Rider Finance, the court reiterated that courts retain discretion to disqualify an attorney under Rule 3.7, even with client consent, to protect the integrity of the judicial process. The court emphasized that this disqualification must be based on a convincing demonstration of prejudice to the opposing party or injury to the judicial process, prejudice to respondent, and threat to trial fairness. Allowing Mr. Gingras to continue as counsel under these circumstances will prejudice respondents' rights and undermine the integrity of the proceedings. Mr. Gingras' personal stake in the outcome, avoiding self-incrimination or further discipline, creates a risk that his advocacy is driven by self-interest rather than his client's best interests. His presence as trial counsel will also force respondent to confront and possibly cross-examine Mr. Gingras as a witness, an inherently prejudicial scenario that blurs the line between argument and evidence. This dual role could mislead or confuse the court and impugn the integrity of the judicial process, which the court has a duty to safeguard. This motion is and will be based upon this notice of motion and motion, the attached memorandum of points and authorities, the concurrently filed declaration of Respondent's Counsel Omar Serrato, all pleadings and records on file in this action, and such further evidence or argument as may be presented at or before the hearing on this matter. Submitted by Omar Serrato, dated August 25 of 2025. The next document in this filing series is the Memorandum of Points and Authorities. Petitioner Laura Owens obtained a temporary DVRO in the Superior Court of California, County of San Francisco. The order was granted on June 10, 2018. The parties entered into a stipulated agreement, resulting in a 2-year CLETS reported restraining order after hearing under Family Code 6200, etc. The order expired on July 10, 2020. The order was issued without admission of wrongdoing by respondent. The petitioner filed a request to renew the DVRO. A hearing was held before the Honorable Sharon Reardon. Over respondent's objections and without finding of abuse, the court granted a 5-year renewal pursuant to Family Code 6345, extending the DVRO until July 10, 2025. Petitioner filed a second request to renew the DVRO against respondent in San Francisco Superior Court on July 10, 2025. A hearing was held on August 15, 2025, whereby attorney David Gingras appeared for petitioner Laura Owens at the hearing on August 15, 2025. David Gingras has since indicated to counsel, Omar Serrato, both verbally and in writing, that he does not intend to represent Laura Owens in these proceedings. This motion is to ensure that he is in fact disqualified from representation due to major conflicts of interest. This motion is expected to be unopposed by petitioner. David Gingras' history with Michael Marraccini. Gingras attempted to illegally engineer respondent's wrongful arrest during the DVRO period by misusing the restraining order in this case, involving law enforcement under false pretenses. Marraccini was lawfully subpoenaed, Exhibit A, the subpoena to appear, to testify at a trial in Maricopa County, Arizona, scheduled for June 10, 2024. As admitted by David Gingras in his declaration to this court regarding the instant renewal, he was aware there would be legal consequences for his failure to obey the subpoena. Finally, please note that it is a felony under Arizona law for any person to unlawfully withhold testimony, to evade legal process to appear, and or to fail to appear when legally summoned. It's doubtful that David Gingras, who's been in practice for roughly 25 years, has as profound a misunderstanding of the law that he reasonably believes Marraccini violated the DVRO by complying with a validly issued subpoena. Yet he cites in his declaration Arizona's Rule 49 regarding discovery disclosures as a valid basis to threaten Marraccini with arrest in an email to David Woodnick. P.S. This goes without saying, but to the extent I suggested Mike would be arrested if he comes to court in Arizona, that suggestion is completely and totally withdrawn. I only said that because I didn't want Mike to show up without giving me the chance to at least interview him as I would with any normal witness. The issue regarding Marraccini's testimony was addressed in a motion in limine filed by Greg Woodnick and addressed by Judge Mata prior to the trial of Owens v. Eckerd. David Gingras argues in his declaration a violation of Arizona Rule 49 regarding disclosures as the reason law enforcement was called, which Woodnick refutes, and offers the basis behind Marraccini's expected testimony, namely that Mr. Marraccini's testimony is important to show her motive, intent, plan, preparation, knowledge, and absence of mistake. There was extensive litigation in San Francisco regarding these parties. Owens claimed to Marraccini that she was pregnant with his twins, that she miscarried, that she needed to take abortion pills, have a DNC because she had a severe allergic reaction to the abortion drug, and that only one of the fetuses was terminated. Laura also allegedly told him she had ovarian cancer, and that she had to have an ovary removed. Fabricated medical records to support this, claimed that she might have cervical cancer, and that she might have Asherman syndrome and Crohn's disease. Laura, after seemingly realizing that Marraccini provided relevant information in the instant litigation, has since claimed that the medical records Marraccini provided, disclosed to Laura, were fabricated. Ostensibly, Marraccini was distressed by Laura, via counsel, posting the 2018 deposition and blogging about him being a liar and 100% false, which led him to surrender his laptop to a San Francisco-based computer forensic expert, John Berryhill of Berryhill Computer Forensics. Mr. Berryhill analyzed thousands of pages of text messages and medical records communicated between Laura and Mr. Marraccini and determined all text messages, medical records from Laura's phone number came from Laura. Meaning Laura appears to be continuing to commit perjury by filing affidavits that disclaim texts and medical records that she sent. It is no wonder she does not want Marraccini addressing her intent, motive, knowledge, absence of mistake, and preparation, despite his testimony being admissible under the rules. Gingras attempted to harass Mike Marraccini through social media, through his former attorney Randy Sue Pollock, and ultimately with the Phoenix Police Department in an effort to intimidate a witness into not testifying at trial. Exhibits F through R. Social media posts where Gingras taunts Marraccini in social media, emails to counsel, and his personal blog published on Gingras' website, both before and after June 10, 2024 trial. When Marraccini arrived as directed in the subpoena, David contacted the Maricopa County Superior Court's Security Department to advise them of the situation. He then contacted court security to explain the situation and to ask them to enforce this court's order. The Phoenix Police Department arrived shortly thereafter, whereby David provided them with a copy of this court's order and asked them to enforce the order as required by federal law. A huge scene was made shortly before trial began because of the large presence of law enforcement. Gingras' transparent attempt at witness intimidation became moot as Marraccini, although a named witness, was not called to testify. That incident, which respondent contends was a bad faith abuse of process by Mr. Gingras, is a central disputed issue in the petitioner's request to renew the DVRO. Mr. Gingras is a precipient witness to the event, and his credibility and conduct are directly in question. Compounding this, Mr. Gingras now has a personal stake in the case beyond his role as advocate. Respondent filed a state bar complaint regarding Mr. Gingras' conduct in this matter. The Arizona State Bar's independent review has resulted in a recommended order of probable cause, meaning the bar is proceeding in its investigation under the belief it has sufficient evidence of ethical violations by Mr. Gingras toward Marraccini to initiate formal disciplinary proceedings. He enters the DVRO renewal hearing with a serious conflict of interest. His own professional fate is at risk based on the facts of this case, creating strong incentives to vindicate himself or minimize his wrongdoing. Much of the basis for Owens' renewal request is focused on Gingras' personal grievances against Marraccini and has little, if anything, to do with Owens' reasonable fear required to move forward with her request. California law holds paramount the duty of attorneys to avoid conflicts and to maintain the integrity of the judicial process. Where, as here, an attorney's personal interests materially limit his representation, and where the attorney is likely to be a necessary witness on contested issues, a court has both the authority and the obligation to disqualify counsel in order to preserve public trust in the fairness of the proceedings. Respondent does not bring this motion lightly, recognizing that parties are generally entitled to counsel of their choice. However, the California Supreme Court has emphasized that the important right to counsel of one's choice must yield to ethical considerations that affect the fundamental principles of our judicial process. In short, the paramount concern must be to ensure a just proceeding untainted by conflict or attorney self-interest. Accordingly, respondent moves to disqualify Mr. Gingras on two primary legal grounds: 1, conflict of interest, and 2, advocate witness. In combination, these factors demonstrate that allowing Mr. Gingras to continue as counsel would prejudice respondent's rights and the integrity of the court. The legal standard for disqualification of counsel. California courts have inherent authority to disqualify an attorney when necessary to protect the integrity of the judicial process and the rights of litigants. A motion to disqualify involves a conflict between the affected party's right to chosen counsel and the duty to uphold ethical standards in litigation. The court's paramount concern is preserving public trust in the scrupulous administration of justice. Therefore, the important right to counsel of one's choice must yield to ethical considerations, where those considerations are fundamental to the fairness of the proceedings. Disqualification is warranted for a variety of ethical violations, but two grounds are particularly relevant here: concurrent client conflicts, personal interest conflicts. Under Rule 1.7 of the California Rules of Professional Conduct, an attorney must not represent a client if there is a significant risk the representation will be materially limited by the lawyer's own personal interests, absent informed written consent from the client. Even with client consent, some conflicts are so severe that they are not truly waivable if they threaten the fairness of the proceedings. The court may disqualify an attorney whose personal interest conflict poses a substantial risk to his ability to represent the client in order to protect the interests of justice, will be materially limited by a lawyer's responsibilities to or relationships with another client, a former client, or a third person, or by the lawyer's own interests. We agree with the trial court's analysis. Simeon has failed to establish the court abused its discretion in denying his motion for reconsideration or in denying him leave to amend his complaint. Advocate witness conflicts. Rule 3.7, a lawyer may not serve as both advocate and witness on a material issue at trial, absent narrow exceptions. This advocate-witness rule exists to avoid prejudice and confusion, as California courts deem the dual roles irreconcilable, requiring partisanship as counsel and objectivity as witness, thereby undermining fairness. Even if a client were to consent to such dual role, the court retains discretion to refuse to allow it, to protect the trier of fact from being misled or the opposing party from being prejudiced. In deciding a disqualification motion, the court must examine the totality of the circumstances and determine whether the attorney's involvement would have a continuing effect on the proceedings, such that the fairness or appearance of fairness is jeopardized. When an attorney's continued representation threatens to undermine the integrity of the judicial process or impacts the moving party's interest in a just determination of the case, the court must exercise its discretion to disqualify that attorney. Ultimately, the trial court has an independent interest in ensuring trials are conducted within ethical standards and that legal proceedings appear fair to all who observe them. This independent interest exists regardless of whether the attorney's own client objects to the conflict. Even a non-client litigant, like respondent here, has standing to seek disqualification when the attorney's conduct infects the litigation and threatens a cognizable interest of the moving party in a fair proceeding. Against this legal backdrop, both prongs of Mr. Gingras' conflict are squarely presented in this case. We address each in turn. Argument. David Gingras' personal interest in avoiding discipline conflicts with his client's interests. Gingras' ability to represent petitioner with undivided loyalty and independent judgment is materially compromised by his own personal interests in this matter. Rule 1.7 defines a concurrent conflict of interest to include situations where there is a significant risk the lawyer's representation of the client will be materially limited by the lawyer's own interests. That is precisely the situation here. Gingras' personal conduct regarding respondent is under official scrutiny, and he has a powerful incentive to protect himself, to defend his reputation, and avoid professional discipline arising from this case. This creates a significant risk that his representation of Ms. Owens will be skewed or impaired by considerations of self-preservation. The Arizona State Bar's probable cause finding is an objective indicator Gingras' conduct in this matter is in serious question. When an attorney's own actions are at issue in the case, ethical authorities warn that it may be difficult or impossible for the lawyer to give a client detached advice. An attorney cannot be neutral or wholly loyal when his personal wrongdoing is intertwined with the client's case. The lawyer's own interests should not be permitted to have an adverse effect on the representation of a client. Here, Gingras' alleged misconduct toward respondent, misuse of the DVRO and law enforcement, is a central issue. He has a personal stake in denying or minimizing that misconduct. This personal stake directly conflicts with his client's interest in a full and truthful adjudication of the DVRO issues. If certain evidence in the renewal hearing might vindicate respondent's claim of attorney abuse and thereby bolster the State Bar charges against Gingras, Gingras has a temptation to downplay or suppress that evidence, even if it might be relevant to Ms. Owens' case. Conversely, Gingras might be tempted to overemphasize or even fabricate justifications for his prior conduct to protect himself, evidenced by major emphasis on the incident related to the Arizona Bar investigation highlighted in his declaration, thereby diverting the hearing's focus away from Ms. Owens' actual interests. In either scenario, his personal interest in avoiding discipline pulls against his client's best interest in objectively fair presentation of facts. California courts have recognized that an attorney who is simultaneously defending his own conduct while representing a client in the same matter operates under a disqualifying conflict. In Kennedy v. Eldridge, for instance, an attorney was disqualified in a family law case due in part to his emotional involvement and personal entanglements that compromised his objectivity and loyalty in representing his client, who was his son. The court noted that such multiple roles and personal stakes undermine the integrity of the judicial system and create at least an appearance of impropriety that cannot be ignored. Footnote 3. Laura Owens' petition for renewal was undoubtedly authored by David Gingras, and his declaration virtually mirrors the facts set forth in Laura Owens' petition. The overwhelming basis of Owens' petition is centered around Marraccini complying with a lawful subpoena, where Gingras is alleged to have abused the DVRO process and law enforcement to intimidate a witness. A client's consent to a conflicted representation does not bind the court when the conflict threatens the fairness of the proceeding. Courts reserve the power to disqualify an attorney if the conflict poses a substantial risk to the attorney's ability to competently and loyally represent the client, or if it undermines the adversarial process, notwithstanding the client's willingness to proceed. As the California Supreme Court has observed, some conflicts are so severe that even informed consent may not suffice to avoid prejudice, especially where an attorney's judgment may be impaired by personal considerations. In this case, disqualification on conflict of interest grounds is warranted because Gingras' personal interest in his own disciplinary outcome is paramount and irrevocably at odds with his client's interests. The situation creates, at the very least, an appearance of impropriety and a genuine risk that Ms. Owens will not receive unbiased, conflict-free representation. The integrity of the court's process is likewise at stake. The fact finder should not have to wonder whether petitioner's counsel is shading his advocacy to save himself. In short, Rule 1.7 prohibits Gingras' continued representation, and the court should exercise its discretion to qualify him on this basis alone. B. Gingras must be disqualified under the advocate-witness rule. Gingras' role as a key percipient witness independently mandates his disqualification. Rule 3.7a bars an attorney from serving as both advocate and witness on a contested issue, absent narrow exceptions that do not apply here. The June 2024 incident, where Gingras reported respondent to police in a misleading attempt to have him arrested, with knowledge Marraccini was complying with a lawfully ordered subpoena in an effort to intimidate a witness on the day of trial, is central to petitioner's request for renewal. Only Gingras can testify about his own statements and motives during that episode, making his testimony necessary and material. Courts have long held that the dual roles of advocate and witness are reconcilable, as one requires persuasion and the other objectivity. Allowing Gingras to continue would create multiple prejudicial effects. 1. Misleading the fact finder by blurring advocacy with testimony. 2. Prejudicing respondent, who would be forced to cross-examine opposing counsel. And 3. Improperly bolstering Gingras' credibility through his dual role, as warned in Comden v. Superior Court. Even with client consent, Comment 3 to Rule 3.7 confirms the court retains discretion to disqualify counsel to protect fairness. Petitioner can readily secure substitute counsel, but respondent's right to a fair trial would be gravely compromised if Gingras remains. The equities thus decisively support disqualification. C. The combined effect of Gingras' conflict and dual role threatens the fairness and integrity of these proceedings. Even if either of the above grounds alone might suffice, together they present a compelling case for disqualification. This is a situation where an attorney's personal interest conflict and advocate-witness conflict intersect, compounding the potential for injustice. Gingras' personal interest, his pending discipline, gives him a motive to color the evidence and arguments in this case to suit his own ends, consciously or unconsciously. This undermines the court's confidence that petitioner's case is being presented ethically and objectively. Simultaneously, Gingras' status as a key witness means he is effectively an unsworn participant in the events being litigated. The fact finder must evaluate Gingras' actions and credibility, yet Gingras, as petitioner's lawyer, would also be packaging those facts for the court. From the respondent's perspective, these conflicts materially prejudice his rights. He faces an opposing counsel who might distort the truth to protect himself, and whose factual claims cannot be tested by normal means, since that counsel also controls what evidence is presented. This is antithetical to a fair adversarial process. From the court's perspective, the proceedings risk devolving into a trial about Gingras' conduct rather than the parties' issues, creating a sideshow that detracts from adjudicating the DVRO renewal on the merits. Additionally, the court must worry that any decision, granting or denying the DVRO renewal, could be tainted by the perception that one side's attorney had a personal axe to grind or that his dual role influenced the outcome. This threatens the integrity and public trust in the judicial outcome. In sum, allowing Gingras to serve as petitioner's advocate would materially compromise the fairness of the DVRO renewal hearing. It would place respondent at an unfair disadvantage and interject Gingras' personal issues into a proceeding that should be about the parties, not the lawyers. The prudent and just remedy is to disqualify Gingras now, before the trial, to ensure that the upcoming hearing can focus on the merits, with both parties represented by conflict-free counsel and all witnesses, including Gingras, testifying without also acting as advocates. 4. Conclusion. For these reasons, Respondent Mike Marraccini respectfully asks the court to disqualify David Gingras, Esquire, from representing petitioner Laura Owens in this DVRO renewal. Disqualification is necessary to eliminate a clear conflict of interest, enforce the advocate-witness rule, and preserve the fairness of these proceedings. If needed, the court may briefly continue the hearing to allow petitioner to retain new counsel, ensuring the matter is resolved on the merits without ethical compromise. By removing Mr. Gingras, the court affirms that justice must not be clouded by attorney conflicts or dual roles, thereby safeguarding both parties' rights and the integrity of the tribunal. And that is signed and dated August 25th by Omar Serrato, attorney for Respondent Michael Marraccini. Here we have the proposed order from Omar Serrato, pre-written to allow the court to make a decision that would find David Gingras a problem in the case and disqualifying him to represent Laura Owens in the DVRO. So that's the overall thing with this particular filing. There are a number of exhibits that are attached. Here we have the subpoena for Laura Owens v. Clayton Eckerd that was sent to Mike Marraccini. This is the subpoena from the Superior Court of Arizona in Maricopa County. And it gave all the details of when to appear and at what time. It is such a thorough subpoena. It has all of the requisite information for those who it has been sent to. We won't read through any of this. This is standard subpoena stuff, at least for Arizona. If you're interested in that, you can take a look at these documents on your own. We will move right ahead. Exhibit B is the declaration of David Gingras, and we've already read through this because it was already filed. I don't feel the need to repeat myself yet again on this thing, so we'll move through this as well. Let's talk about some of the things he's trying to advocate for Laura Owens. That is also a conflict for his bar disciplinary actions, or at least pending actions. We'll skip through this. Exhibit C, we'll skip past this a little bit because there's some personal information that wasn't fully redacted, was sent to Mike Marraccini in response to his complaint filed against David S. Gingras, Esquire, Dewey the Douche Canoe.
The fucking douche canoe.
Let's read this because this is new to me. Dear Michael Marraccini, we have completed our investigation into the matter listed above. After our investigation, we have decided to recommend to the Attorney Discipline Probable Cause Committee the following disposition of the matter: order of probable cause. We thoroughly investigated this matter, which included reviewing the charge, Mr. Gingras' response, and Mr. Gingras' supplemental responses. We assume that, as the complainant, you do not object to our recommendation. I suspect he doesn't. Nevertheless, you have the right to object, etc., and there's things in which one must submit if they wish to object to their finding. I doubt. I've already said I doubt Mike will object to their finding because this is now going to go before the committee to review in its entirety and see if there's cause in which to write up Dingus the Douche Canoe, Dewey the Douche Canoe for charges being a member of the bar. So this could be the beginning of the end for Mr. Gingras' law career, or some of us hope that, at least. He said again in his now deleted Twitter, he wants to leave the Arizona bar on his own terms, but he may have no choice. But on the other hand, this could also be a scenario that's similar to Leslie Frederigo's, who was given the option of either retiring permanently or facing disciplinary action. And of course, Legally Lips, Leslie Frederigo's, decided to involuntarily, supposedly, be retired, even though she still pretends to act like a lawyer here and there. For more information on that, follow the What the Hales case as regularly presented by the one and only Megan Fox and that umbrella guy Tug. It's very fascinating stuff. I watch it fairly religiously, but I only have the bandwidth to cover one thing at a time, and Laura Owens is it. This is such an extraordinary case. I can't help but just do this one for the time being, but we may go back. We'll see. Who knows what the future holds? Exhibit D is an email from David Gingras to Greg Whitnick, and it's about looking at Mike's laptop. We don't really need to read that because there's the thing we pretty much read that was inserted in the filing. So we'll skip ahead for this. Exhibit E is Laura v. Eckerd stuff. We won't cover that stuff again because this is about Laura. This is all about Laura. This talks about some more things about disclosure of witnesses and so on and so forth, which is referenced in the filing. Exhibit F is a blog that is now deleted from the Gingras Law Office website, and it was titled, Let's Talk About Lies Part 2. For those of you who caught this as it was posted on the Gingras Law Office blog, you know what the content of this is, and it sort of disparages all kinds of people, including Clayton and most of the other men that Laura Owens was trying to abuse via the legal process. All of that was essentially more in defense of Laura, and it's unnecessary. And of course, it included pictures in the Gingras Law Office blog. Exhibit G are Twitter postings by Dewey the Douche Canoe, David S. Gingras.
The fucking douche canoe.
I may end up breaking that button. It gets so much use. Oh well, many of you have caught these as they were posted live. Exhibit H appears to be more Twitter postings by Dewey the Douche Canoe. I won't push it this time. I'll spare you. Exhibit I. Oh gosh, the size has changed. Exhibit I is more Twitter stuff posted by Dingus the Douche Canoe. Exhibit J. We'll keep it small because the sizes keep changing and then they get too small. More Twitter postings by Dingus. Exhibit K. More postings by Dingus mentioning Mike Marraccini specifically. And more disparaging and defamatory comments. Exhibit L. Continued Twitter comments by David S. Gingras. Exhibit M. More Twitter comments. And sort of defense of his improper conduct, too. That's naughty, David. Oh, I so look forward to his being disciplined. Exhibit N. More Twitter from Dingus, including pictures. Exhibit O. More Twitter from Dingus. Exhibit P. More Twitter. Exhibit Q. More Twitter. Exhibit R. This is the letter from David Gingras to Greg Woodnick, and it talks about the computer and all of that stuff. This specifically mentions how Laura is not afraid to talk to Mike on the phone personally and directly. So this very much disqualifies, well, not only Dingus as being her counsel, but it also represents a certain fact pattern. That fact pattern being that she's not afraid of him, and she used the system and the DVRO process just to punish and abuse and make his life a living hell. So this is all part of her MO, and this is, we hope all of this leads to more criminal prosecution, but not just in Arizona, also the state of California, for the same things, essentially, as what's being prosecuted in Arizona. I think that may be the end of this filing. Let's keep looking here really quickly. Yes, that is the bottom. So this concludes the filing and the motion to disqualify Dewey the Douche Canoe, David S. Gingras Esquire.
The fucking douche canoe.
That'll be the last time you hear that one for this one this evening. And thank you all to your patronage, your support, your clicking like, and making comments. Of course, that supports the algorithm here. So in our next episode, we will take a look at the response from Mike Marraccini with the DVRO filing. And having watched the amazing Megan Fox and Sister Stephanie, Sister Fox as I call her, there is some good juicy stuff in that response, which we will get to after this. So stay tuned for the next episode.